Evening. Do you know why I pulled you over? License and registration.
Sir, do you have any weapons in the vehicle tonight? 5 words. That's genuinely all it takes for a routine traffic stop to become the worst night of someone's life, and not because of what's actually sitting in the car. In 20+ years of criminal defense work, I've represented people who lied about a completely legal, registered firearm in their glove box, and that lie alone turned a broken taillight stop into a felony charge. I've also represented people who said nothing at all because somebody online told them silence is always the safest move in a state where staying silent about a firearm was itself against the law. That silence turned into handcuffs. So today, I'm breaking down exactly what you are and are not required to say when an officer asks if you're armed, because this is one of the only moments in a police encounter where both talking too much and talking too little can hurt you, and almost nobody knows exactly where that line sits until they're already standing on the wrong side of it. Here's where a lot of good advice gets misapplied. Your hormuck. If you've spent any time learning about your rights, you've probably heard some version of the same rule. Never answer police questions. Invoke your right to remain silent. Let a lawyer do the talking. That advice holds up in almost every situation. A no, interrogation rooms, requests to search your car, questions about where you're coming from or where you're headed. But do you have a gun in the car? Isn't quite like those other questions. Because in a meaningful number of states, it isn't purely optional. It's a legal trigger. Depending on where you're standing when the lights come on behind you, you may have an affirmative legal duty to disclose that firearm the moment an officer asks bond, or even before they ask. Treat every question in a stop as optional and in the wrong state, into someone facing an obstruction or failure to report charge, on top of whatever the original stop was for. Picture the scene appall. And I want to be clear, this is a composite built from patterns I've seen across dozens of stops, not any one specific case. It's a little after 11 at night. Marcus is driving home from a late shift, doing everything right, when a set of headlights fills his rear view and blue and reds come on a second later. His registration tag expired 3 weeks ago for us. He genuinely forgot to renew it. Nothing more sinister than that. He pulls onto the shoulder, puts the car in park, and does the thing every defense attorney will tell you to do first. He rolls down the window, puts both hands on top of the steering wheel where they're visible, and waits. The officer approaches from the driver's side, flashlight sweeping the back seat before it lands on Marcus's hands. License and registration. Standard opening. Marcus hands them over. Then comes the question this whole video is built around. Any weapons in the vehicle tonight? In that half second of silence before Marcus answers, 2 competing instincts are fighting each other. One says, you don't owe this man anything beyond your name and your documents, Paul. Stay quiet, protect yourself. The other says, lying, or flatly refusing to answer. This might be the single most dangerous thing you could do right now. Both instincts come from real legal principles. The problem is knowing which one actually applies. Let's back up and build the legal foundation, because you can't understand the gun question without understanding what the stop itself legally is. The Fourth Amendment protects you against unreasonable searches and seizures, and a traffic stop counts as a seizure in the eyes of the law, but a limited one. Back in 1968, the Supreme Court decided a case called Terry v. Ohio, which is the foundation of almost every roadside encounter in this country. Terry established that an officer doesn't need probable cause of a crime to briefly detain someone. Reasonable suspicion is enough kairaf, and if that officer reasonably believes the person might be armed and dangerous, they can conduct a limited pat-down for weapons, just to check for anything that could hurt them. That's the constitutional root of officer safety questioning. The Supreme Court expanded on that officer safety logic twice more in ways that matter directly to Kasran's stop. In Pennsylvania v. Mims, decided in 1977, the court said, an officer can order a driver out of the vehicle during a lawful stop without needing any extra justification, purely as a safety measure. And in Michigan v. Long, from 1983, the court went further and said that if an officer has reasonable suspicion someone in the car is dangerous and could gain immediate access to a weapon, they can search the passenger compartment share, not the trunk, specifically the passenger compartment share for that weapon, even without an arrest. And under Rodriguez v. United States, decided in 2015, none of this gives an officer license to stretch out a stop indefinitely. Once the reason for the stop is resolved, the detention has to end. Unless something else during the stop, like a visible weapon, gives them independent, reasonable suspicion to extend it. Notice the theme running through these cases. Terry, Mims, Long, Rodriguez courts have consistently treated officer safety around weapons as its own distinct legal category, separate from whatever the stop was originally about. That's exactly why the "do you have a weapon" question doesn't fit neatly into a blanket never talk to police strategy. It isn't aimed at building a criminal case against you. It's aimed at getting the officer home safely at the end of the shift. And the law has built an entire structure around protecting that goal. So does that mean you have to answer? This is where it gets state-specific, and it's exactly the part most people get wrong. Owning or carrying a firearm legally is not a crime, which means telling an officer you have one is not self-incrimination in the Fifth Amendment sense. You can't invoke the Fifth to avoid disclosing something that isn't itself illegal. That matters because it means the usual "I decline to answer" script doesn't carry the same constitutional weight here that it does when police ask whether you've been drinking or where you're coming from. On top of that, a meaningful number of states have what's called a duty to inform law, specifically for people carrying under a concealed handgun permit. In those states, the moment a permit holder is stopped by law enforcement, they're legally required to proactively disclose that they're armed, a TOUB, sometimes before the officer even asks. Other states have no such requirement at all and treat it as a question you're free to decline. The catch is that you can't guess your way through this in the moment. It's tied to the specific statute of the specific state you're standing in, and it can differ from the state where your permit was issued if you're traveling. I'm not going to pretend I can walk you through the rule in all 50 states in one video tutorial. What I can tell you is that if you legally carry a firearm, learning your own state's disclosure requirement before you're ever pulled over isn't optional homework. It's the single biggest factor standing between this being a 5-minute stop and this becoming an arrest. Back to Marcus. In his state, permit holders are required to disclose immediately. He knows this because he did his homework the day he got the permit phone. And this is exactly the moment that homework pays off. He doesn't freeze and he doesn't overthink it. He says calmly, hands still on the wheel, "We're simply going to turn around now and drive home. Officer, I want to be upfront with you to know I have a valid permit and there's a firearm in the glove box. I'm telling you now so there are no surprises. Beyond that, I'm going to respectfully exercise my right to remain silent about anything else." Read that again, because I want you to remember the structure of it, not just the words. First, it satisfies the legal disclosure obligation immediately and without being asked twice. No hesitation for the officer to read as evasive. Second, it draws a clean, explicit line the moment the mandatory part is finished. So there's no ambiguity about where compliance ends and the right to silence begins. Third, it's delivered in a calm, cooperative tone, because how you say something like this matters almost as much as what you say. Officers escalate based on perceived threat and perceived deception, not based on the mere fact that someone has a legal firearm. Now let's talk about why the other path, lying path, is so much more dangerous than most people realize. If Marcus had said, "No, nothing in here," with a legally registered gun sitting in the glove box in a duty-to-inform state, he wouldn't just be failing to disclose. He'd be making a false statement to a law enforcement officer during an active stop, which in most states is its own separate criminal offense. Oh, sometimes a misdemeanor, sometimes elevated depending on the circumstances. And practically speaking, that lie almost never survives contact with reality. Officers are trained to look for exactly the kind of physical cues Michigan v. Long is built around: a glance toward the glove box, a shift in posture, hesitation before answering to Fio. And if a protective search under Long ends up finding the object anyway, the lie hasn't avoided a search. It's just been added on top of one. And that's usually the thing that actually escalates a routine stop into an arrest, a night in a holding cell, and a criminal record that has nothing to do with the gun itself. So let's turn this into something you can actually use, whether you carry a firearm or not. First care, hands visible, always, the second you know you're being stopped. That single habit does more to keep a stop calm than almost anything you say afterward. Second clown, if you're a permit holder, learn your specific state's disclosure rule before you're ever pulled over, not in the middle of the stop. It takes a few minutes to look up, and it changes everything about how this moment goes. Third top hand, if disclosure is required, say it early, say it plainly, and don't bury it inside a long explanation. Short and calm reads as honest. Long and nervous reads as evasive. Fourth crayon, once you've satisfied any legal requirement, you're allowed to stop talking. You don't owe an explanation of your day, your travel plans, or anything else. And declining to elaborate further is not obstruction. Fifth, if an officer asks to search beyond what Terry or Long would allow, just say no. I don't consent to a search, even while remaining fully cooperative in every other respect of town. Those two things aren't in conflict with each other. And sixth, write down everything you remember the moment the stop ends a tom. Badge number, patrol car number, timestamp, exact wording anan while it's still fresh, because if the stop is ever reviewed later, your memory from that night is worth more than you'd think. Marcus's stop, in the end, is almost anticlimactic towers, which is exactly the point. The officer runs his information, conforms the permit is valid, writes him a citation for the expired registration tag, and sends him on his way in under 10 minutes. No search beyond a quick glance toward the glove box. No raised voices, no backup called in. Nothing about that night makes the news, and nothing about it ends up in a courtroom. And that's not an accident. It's what happens when someone understands the two different legal tracks running through that one simple question call, the mandatory disclosure track, and the everything else is optional track, a TROMS, and doesn't let adrenaline blur them together in the moment it matters most. If there's one thing I want you to walk away with, it's this: never talk to police is a good general instinct, but it's not a universal rule, and treating it like one can genuinely work against you in exactly the situation you're trying to protect yourself in. Know the difference between what the law requires you to say and what it merely allows you to say, and you'll walk into that traffic stop with something most people don't have going in the sow: an actual plan. Introduce plan. And that weapons question isn't even the only moment in a routine stop where people accidentally talk themselves into trouble. There's another question officers ask constantly, one that sounds even more casual than this one, that trips up more people than almost anything else during a stop a dow, and I'll break that one down for you next.